right, my friends. I just pressed the Let's Go Live button, which means we gotta wait for the stream to fire up all across the fruited plain of the interwebs. Before we go ahead and get started, we got a new filing in Fani land that we have to talk about, which is going to be a lot of fun. Another victory for the defense. But let's make sure the tubes are connected on the Rumble, on the locals, on the YouTube, and the Telegrams. It looks like they are. That is tremendous. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Fani Willis and how she has lost again. And boy, we've covered a lot here with Fani, and we've seen how she fails pretty repeatedly. She failed to get convictions out of Jenna Ellis, Sidney Powell, Kenneth Chesebro. She failed to get Harrison Floyd remanded back into custody, and she's failing again. She can't even properly indict somebody without that being dismissed because Judge McAfee came out and dismissed 6 counts, quashed 6 charges in the indictment, and we're going to see what is inside. We're going to take a look at the order from the judge. This has been something that was submitted, joined by many different defendants, and this is a big deal. And we have a summary of the different charges, and you'll notice, whoa, Anna Bauer put this together. You'll notice that one of those charges that was dismissed is that very interesting phone call that took place with Brad Raffensberger on January 2nd. Remember that? The perfect phone call? That criminal charge is gone, along with 5 others. 3 of those applied to Trump, so Trump is down 3 additional charges from when we started this morning. And we're going to see what is left. So I went out and put together a little summary of what Trump's original charges were. You can see there were 13 there. Dismissed today were 6 additional charges, but 3 of those were for Trump. And hopefully I did the math and the equations correctly. 13 minus 3 equals 10, I'm pretty sure. All right, I'm a lawyer, cut me some slack. So he's got 10 charges left. And I actually went through and summarized what those were so we can peek inside and see what is left, what else is there. And they're basically, paperwork documents. It's a conspiracy charge. They signed some documents about alternate electors. They made another document and they submitted some paperwork into the court. And they also submitted some paperwork to the Secretary of State saying your election was terrible, because it was. We know that. And of course, Trump got indicted for those counts. Those are what are remaining. So we'll see what's inside. We also have Trump's attorney, Steve Sadow. He responded with a very short statement. A lot of people are trying to unpack this. What does this mean? Is this going to lead to Fani's disqualification? Is he trying to maybe split the baby on this one and give everybody a little bit of a bone because he knows he's not going to disqualify Fani? We're going to talk about all that. But Steve Sadow is celebrating the win. He's saying, look, the whole thing should go away, but this is a step in the right direction. And so we'll see what he says. We've also got some reaction from Raskin. Raskin was out. He got asked about this by Manu Raju over on CNN. And so he came out with a very short statement. And so we'll hear what he says. We've also got a clip from Raffensberger. Raffensberger, of course, the Secretary of State, who is on the other end of that so-called perfect call. And I got a clip from him as well, because he's getting asked. They're like, hey, buddy, guess what? They're like, guess who's back? Trump is. Oh, he's going to be on the ballot again. So how you feeling about that, Brad? We'll see what he has to say. Of course, all in our first segment as we unpack the ruling, which is the big reason we're here. We'll go through it. We'll see. It's kind of a clerical thing. I think Fani could easily fix this and go through the indictment process again. But the whole question is, can they get this done before the election? And that's looking less and less feasible as the days go by. Then we're going to talk about what this dismissal means. What does this ruling mean? Because we had a conversation about this morning on our watchingthewatchers.locals.com members only platform, but I've given it some more thought, and we've kind of broken down the 3 different possibilities that this could play out. We're asking, okay, so those 6 charges are gone. What does this mean? Does this mean that the judge might dismiss and disqualify Fani? Maybe. Do we think it's just a token victory and he's not going to disqualify or dismiss Fani? We'll talk about that. We've got some other possibilities. We'll also talk about whether this could be potentially a warning for Fani, right? The judge is dismissing or going to be disqualifying the case but not dismissing the case, or this could just be slowly knocking the legs out from the table that is Fani's so-called prosecution, right? So this is just knocking out one of the four legs, just telling everybody this is a wobbly case to begin with because he's about to come out, do the right thing, disqualify and dismiss the case. We'll talk about it. We also have some questions about Judge McAfee and what he's up to. He showed up on the Shelley Wynter Show and spoke about his campaign. This is his first campaign. He got appointed to this position, and he spoke for about 7 minutes, and he tells us a little bit more about himself and about his relationship with his kids, and it's actually a very nice clip. So we'll listen in on that, break down what's happening there before we turn to some others for reaction. CNN, they brought Elie Honig out. He's a former prosecutor from the DOJ, you know, one of them. And he said this is embarrassing for the prosecutors, which is obviously true, because Fani should have been able to properly plead and properly indict somebody, but they failed at even that because they're just terrible lawyers. They're just not any good. And then Abba is back in the house. And she says, Fani, whatever the heck her name is, who cares? This is a good step in the right direction. At least some of the charges are gone, and hopefully we come back and we have more charges that go bye-bye. And so, as you can see, my friends, we got some good business to attend to. We got a little bit of radio to listen to. We've got some opinions and rulings to unpack. And so we're grateful that you are here and with us today. We're also hopeful that you're being healthy out there, my friends. And one way to do that is with our friends over at Field of Greens. Yeah, baby. Field of Greens now. Of course, you know who they are, Field of Greens. It's the healthiest thing that I do every day. And I want you on the journey with me to health. It's literally 1 scoop a day. You just open this up. Tastes great. They have flavors now, so you can try a bunch of different stuff, and it's completely improved my life and how I feel. This is nutrition the way nature intended. Field of Greens. Now, why do I love Field of Greens? Very easy. Way more energy throughout the day, sleep better throughout the night, healthier hair and skin, helps with digestion, settles the stomach a bit, just feeling better and healthier overall. And Field of Greens is radically different. Each organic fruit and vegetable was medically chosen to support heart and vital organ health, and I trust Field of Greens to keep me healthy. And I promise you're going to love this product, but if for any reason you don't, they'll give you a 100% money-back guarantee. And here today, we got you 15% off your first order, plus free rush shipping. Very easy to get it. Just visit fieldofgreens.com. Don't forget to use code Robert when you check out. That's code Robert at checkout, fieldofgreens.com. Again, fieldofgreens.com. The vegetables want to be eaten. That's why they're on this planet, and they're delicious and nutritious. This hair is not included, probably. We also have watcherlodge.com. Don't forget to go over there and register at watcherlodge.com. We got a great free event coming up this Saturday for 2 hours. We want to have you come and join us, discover your purpose and your goals workshop. If you're kind of off keister on that a little bit, we're going to help break that down with Mama Govea, Marianne. She's amazing. Also, we have our website, robertgovea.com. If you want to grab the PDF or sign up for our newsletter, that's where you do it. And our after party and member-only streams in the morning happen at watchingthewatchers.locals.com. And they happen for our YouTube members who sign up and join us over there. All right. And now, without any further ado, let's get right into the business on the day. Fani loses again. Judge McAfee comes out, drops a ruling, but not the ruling. We're still waiting for the big one. The disqualification and the dismissal opinion from Judge Scott McAfee out of Fulton County. But this is a good one. 6 counts that were originally brought in Fani Willis's prosecution, now gone. Why? Because Fani and Nathan didn't know how to write an indictment. They just made broad, vague terms and said, you violated your oath. And what oath? There's a lot of oaths. There's a lot of things that could be in that. So you need a little bit more specificity. And because you didn't have that, they're gone. And the charges we're talking about include that perfect phone call. We're going to see what is now gone. We're also going to see what is left as we break down what remains in the Trump indictment before we get reaction from Trump's lawyer, Raskin and Raffensberger. But let's go right to the opinion. Judge McAfee dropping this, catching everybody by surprise. Everybody's inbox went, and everybody thought, oh, Judge McAfee, a new opinion. Is this the disqualification one? Not quite yet, but we're on the way there. And the question is, what does this do to that other opinion? Are these two things that are completely separate and apart from one another? Does this decision have some bearing, some weight on the other decision that we're still waiting to drop? Are they correlated or not? We'll see. We've got some analysis coming up on that we'll come back to. But here's what happened. 9:23 in the morning, as we sit and wait for the other decision to drop, State of Georgia versus Donald Trump and the co-defendants, Fulton County, of course, prosecutor Fani Willis, they're representing the government. This is Judge McAfee writing, saying, all right, the defendants, Trump and these other defendants who all filed or joined these motions, they challenge counts 2, 5, 6, 23, 28, and 38 of the indictment by way of a special demur. Now, what the judge is telling us, and we're going to understand what a demur is, it's basically saying that the underlying charges are invalid because they're not specific enough, and they got to be specific so that the defense can properly prepare a defense. You just say, well, you broke the law generally. You're like, okay, well, how can I, what do you mean? You need some specificity. So they say here, these are the people involved, obviously, Trump, Giuliani, Eastman, Meadows, Smith, and Cheley, all submitting directly or through adoption an effort to get rid of those 6 charges. Now, before we understand what a demur is, let's talk about the charges, because I think the charges, if we know what the charges are, we'll see how a demur applies to this. So what we have from Anna Bauer, who is a great reporter doing great work at Anna Bauer on the X platform, she put together this summation of the charges. And let's open this up so we can zoom in on this just a smidge and see what is happening here. You can see that there are these 6 counts listed. She writes, these are the charges dismissed in the Fulton County election interference case. So we're asking ourselves about the nature of these charges. Okay, what type of charge are they? We've got 6 different charges with different co-defendants. So Giuliani, Eastman, and Smith on the first one. The charges are Eastman, Smith, and Giuliani. They were soliciting a public officer to violate their oath, right? So we're going to see that same pattern. So just come back to that. Officers violating their oath. Okay, well, their oath is, to uphold, defend the Constitution, whatever. So that's a pretty big one. Anything like in the oath, like to uphold the law, does that mean a traffic ticket, or how did they do the oath? What part of the oath? Give us some details. So anyways, they say this is what Fani said originally. December 3rd, there was a state meeting, Georgia State Capitol, Rudy Giuliani, Eastman, they show up. And they're asking public officers, right, at the hearing, so it's a public hearing, or whatever the hearing was, maybe it was a meeting, said, hey, we've got an alternative theory. You should have an investigation into this. So they said that they were asking them, soliciting them to violate their oath. All right. They also charged Trump with doing the same thing, soliciting a public officer to violate their oath because he placed a phone call, not the perfect call, to Georgia House Speaker David Ralston. So Trump calls, says, hey, listen, we've got a theory that there's another outcome here and we're investigating. So this is what the House should do, right? Trump's investigating. Count 6 also going to be going away. But this again was Giuliani and Smith, again, soliciting a public officer to violate their oath. This was a different meeting. Giuliani, Smith, several other people who were not indicted, they held a meeting at the Georgia House of Representatives and its Governmental Affairs Committee. So they show up, say, hey, we've got this alternate theory. You should do something about it. Fani says that do something about it is a violation of their oath, and they were soliciting somebody to do that. 23. All 3 people, Giuliani, Smith, and Cheley, charged with soliciting a public officer. There was another meeting, this time in front of the Senate Judiciary Committee in Georgia. 28. Trump and Meadows. Now, this is the big one. Count 28 charges both Trump and Meadows with soliciting a public officer to violate their oath. And that was during the infamous, quote, perfect phone call that Trump and Meadows held with Georgia Secretary of State Brad Raffensberger, the so-called find me the votes call, which was perfect. So that was, again, soliciting an officer. Trump was doing the soliciting of an officer to violate their oath, whatever that oath was. Count 38 charges Trump, again, with sending a letter. This time was another letter encouraging Brad Raffensberger, again, the secretary, to decertify the election or, quote, whatever the correct legal remedy is and announce the true winner. So saying, look, you're the secretary, go investigate this stuff and then announce the true winner of this since you know your elections are terrible. And they are, by the way. I mean, we've seen it. Amy Totenberg, who is not a MAGA judge by any way, shape, or form, already wrote an opinion in another case there in Georgia saying your elections are terrible. This started back in 2018, has been going on ever since. All right, but the pattern you see is they're asking a public official to violate their oath of office. So what does that mean? Let's see. The judge now is considering those charges, and he's saying that a demur that came from all of the defendants who were charged with those types of crimes, it provides a means for the criminally accused to ensure that the state's charging document satisfies the constitutional mandates of due process and the Sixth Amendment. And they say here, right, under the U.S. Constitution, the accused shall enjoy the right to be informed of the nature and the cause of the accusation. If you are charged with a crime, you want to know the details of the crime. If they say you're charged with murder, they say to you, okay, well, you killed this person on this date and time. This was the weapon used. Here's the theory of the case. Here are the witnesses that come after you, all the things. Think about it. If it would have just been, you broke the law. You're arrested. You go to jail forever. For what? Well, whatever we say, because we're the government. We don't have to give you due process. We don't have to give you notice of the charges, the right to contest them, the right to confront your accusers, or any of those things, right? There was a time and place before we had a written constitution where that was the norm. You just got arrested, thrown in the gulag somewhere, and that was that. And I think a lot of people in this country would like to go back to those days, and they don't like due process. But the point here is that Fani was just saying that they violated some random oath. And we can't know the nature and the cause of the accusation by just pointing to some platitude like that. You violated your oath. Okay, how? And what part of the oath? And what did I do? A special demur challenges the form of the indictment. So this is what the defense, Trump's team, and others did. They claim that the defense is entitled to additional information or specificity. And there's another case that requires the offense be stated with sufficient certainty. So if Trump wants to rebut that they asked somebody to violate their oath, they need to know what the violation was. So they say pretrial, this is Judge McAfee writing, pretrial, a charging document is expected to be, quote, perfect in form as well as substance. McAfee says the challenged language of an indictment should be interpreted liberally in favor of the state, with any objections strictly construed against the defendants. Talking about who has the burden here. Now, despite this, right, so we don't want, in other words, a defendant to come in and just say, oh, that's not detailed enough. Okay, I needed to know what weapon it was. I needed to know what the caliber of the bullet was. I need to know who, all the details. And because you didn't specify that in the indictment, it has to be dismissed. No, it's not that strict. But you got to have some details. Now, any objection strictly construed against the defendant. Now, despite this, they say, a pretrial challenge does not require a showing of prejudice, and the trial court should examine the indictment from the perspective that the accused is innocent. So when I'm weighing all of this, like I do have rules, I can't just say, okay, anything that's a minor detail, oh, sorry, indictment's dismissed, no. But when the defense does object, I'm going to look at it and look at it through a lens that presumes that the defendant is innocent because, of course, we have the presumption of innocence in this country for the time being. So in other words, let's say that you just were walking down the street. Some, cop says, hey, Rob, you're under arrest. You're coming with us. What charges? And you have literally no idea what's going on. You're arrested for murder. What? I was doing the show. You were there. And if I had zero knowledge, I would need enough to be able to prepare my defense. Okay, who's dead and where did it happen? What? Give me some details. So presume that the defendant is completely blank, right? Lacking any knowledge of any incriminating facts that were alleged by the government. They say, here's what our appellate courts have provided. This is a well-used standard for evaluating this. So Trump's team says, you're just pointing to some vague oath that was violated, but we need more. Here's the test according to Georgia law. They say the test is not whether the indictment could have been made more definite and certain, because obviously you could always have that, right? That's kind of an impossible standard. Could it have been more specific? Yeah, I mean, it always could have. That's not the test. The test is whether it contains the element of the offense intended to be charged, and it sufficiently apprises the defense of what he must be prepared to meet so that they know what they have to defend against. And in any case, any other proceedings are taking against him in a similar offense, whether the record shows with accuracy to what extent he may plead a formal former acquittal or conviction. So it's about notice and process. So here he gives us an analogy. He says, let's use a civil analogy. A special demurrer is akin to a motion for a more definite statement or a bill of particulars, right? It's what's specific in the indictment. Now, the ultimate purpose is to put the defendant on notice so that they know what they've been charged with, and it's to protect against double jeopardy. So the state is very clear. We're charging you for this specifically, this date and time, this location, this venue. These are the elements of the offense. You're guilty. So that another person can't charge a similar crime and hit you twice. Now they tell us due process is satisfied where the indictment puts the defense on notice of the crimes with which he or she is charged and against which he must defend. Now they're pointing us to footnote 2. And here's what that says. They say the defendants here highlight this frequently cited provision to argue that an indictment must score a flawless 100% on a graded scale. Now, the origin of this legal phrase does not appear to set such a high bar, limiting perfection only to time and place. Okay, so time and place have to be dead accurate according to Georgia law, 1877. And as the Georgia Supreme Court has pointed out, imperfections in the indictment are regularly overlooked when an indictment contains an immaterial defect, such as a misnamed code section, the misspelling of a drug, or think about that, right? They come in, they're like, you're charged with possession of methamphetamine. You're like, the heck I am. I'm not charged with possession of methamphetamine. I don't know what the heck that is. Not me, though. And you go all the way to trial, and you go all the way up, and you have your whole case presented, and they say, and that's why you should find him guilty of methamphetamine possession. And he says, sorry, your indictment says methamphetamine. You go, innocent, right? And there's validity to some of those arguments, right? At times they'll cite the different code section, not a misnamed code section, but a different code section. They'll charge you under one theory and another theory. So these things absolutely matter, which is why obviously there's case law on this. At some point somebody said, they charged me with methamphetamine. There's no such drug, and that had to be appealed. So the misspelling of a drug or even the alleged date of the crime in some cases, indicating that perfection may be more of an aspirational statement than an exact working standard. So there's some case law, some judge somewhere in Georgia said it needs to be 100%, so awesome judge, sounds like he's right, pro-defense, government's terrible. It says it got to be flawless. And then they walked it back. No, it's only about time and place. And as long as it's immaterial, then some of the mistakes can be papered over. So he says, okay, so that's the background. So you file a demur. We have some rules now. It's not about whether it's perfect. It's just whether about the defense can properly defend themselves, because that's due process. Now, turning to the indictment itself, Judge McAfee continues. He says these 6 challenged counts that we reviewed charge various defendants with solicitation. So they're asking for a public officer to violate their oath. He says, well, the crime of violation of oath by public officer, here's what it says. It prohibits any public officer from willfully and intentionally violating the terms of his or her oath as prescribed by law. Very vague. Now, the term of the oath alleged to have been violated, it must be, quote, expressly prescribed, meaning it is explicitly contained in the applicable statutory provisions. So it's not just some vague generic, oh, you violated you asked them to violate their oath. I did? How? I was just saying, can you please make sure your election's not rigged? Sorry. You asked them to violate their oath. Okay, where? What oath? What did I do specifically that was asking them to be criminal? Fani didn't do that. She didn't plead that. She was too busy indicting Nathan Wade. So here's this case from Georgia. It reversed when a police officer's oath did not expressly include a provision to uphold the state law. Now, the state must also, more case law, saying the state must present evidence that the defendant violated the terms of the oath actually administered and that those terms were from an oath prescribed by law. So here another indictment withstood a general demur by specifying the violated term, getting some details. So it's tightening the rule. You can't just point to some vague abstract concept. And criminal solicitation, the law itself, 1647 under Georgia, it prohibits one from intentionally soliciting, requesting, commanding, importuning, or otherwise attempting to cause another person to engage in felony conduct, right? And we're going to come back to that because the question is going to be, what was the felony conduct, right? It's a necessary element before you can build upon that with another charge of solicitation. You got to have the felony that you're asking about. Otherwise, you're just asking about something. You know, which way is this? Which way is the McDonald's? It's over this way. Okay, that's not a felony, right? That's soliciting information, but that's not a felonious solicitation. So the 6 counts are similarly structured, and they can be summarized as follows. So here the judge tells us, he says, okay, count 2. It says multiple defendants solicited elected members of the Georgia Senate to violate their oaths of office. Again, we don't really know how, on December 3rd, by requesting them to unlawfully appoint presidential electors, right? And what let me get through these and then we'll come back to this. Count 5 says, alleges that Trump solicited the Speaker of the House of Representatives to violate his oath of office, and he did it by requesting him to call a special session to unlawfully appoint presidential electors. We're still talking about what part of the oath. Count 6 alleges that Smith and Giuliani also solicited members of Georgia to violate their oaths of office by requesting them to unlawfully appoint presidential electors. So conversations about an alternative theory, these alternate electors, felonies, right, for Fani. 23 says that defendants solicited elected members of Georgia's Senate to violate their oaths at a Senate hearing. 28, Trump and Meadows solicited Raffensberger by requesting him to violate his oath of office. And then they asked him, again, Raffensberger, to decertify the election on September 17th. So that's the nature of what we're talking about, summarized by McAfee. So he continues. He says, defendants first argue, so Trump and co., they say they first argue that the indictment is defective because the charging language does not cite the oath that each of these solicited public officers was required to take. So it wasn't specific enough that it gave the actual oath, like verbatim. Okay, so it should have said that, the Speaker of the House, who Trump had a conversation with, what oath specifically did he take? They didn't reference that, meaning we can't see what the oath was, meaning we can't know what the possible violation was, so we can't defend ourselves, therefore it's facially invalid. That's their argument. Now he's saying, no, that doesn't cut it. That's not enough, okay? This omission is legally harmless, he says, as the code provides only one option relevant to each category of public official. So you can know what this oath was that the conduct allegedly violated by just looking it up. Each Georgia senator and representative, the law says, they must take the oath prescribed in 28-1-4. So you know that. So you could just go, okay, you want to see what the House of Representatives guy said? Go look at that one. Georgia senator, look at 28-1-4. The governor, he takes an oath under 45-12-4. And the secretary takes one under 45-3-1. And so if you wanted to know what Brad did, like they didn't cite that he took an oath under 45-3-1, but you could have gone and found that. Now, without the possibility of alternative oaths, so the law says it's this, you don't get to choose, prescribed by the law, the court agrees with Fani that the defense are sufficiently apprised, you have notice, you have due process, of which oath is issued in each indicted count. Now, in a supplemental filing submitted in February, Fani and her office, they detail information provided in discovery concerning the exact oaths administered. So they say that the constitutionally sufficient notice provided by a sufficiently detailed indictment, this is McAfee says, may be supplemented by the pretrial discovery. Okay, so even if they didn't tell you at the outset in the indictment itself what the original oath was, they supplemented it. And they said, okay, this one exactly for Raffensberger, this one exactly for this guy, this one exactly for that guy. So this observation, says McAfee, does not directly suggest that discovery, even if voluminous, is an adequate legal remedy to special demur. So it doesn't mean that you can just paper over it, right? If the indictment is problematic enough, you can't just dump a bunch of additional discovery on it to fix it. Nor is the defendant entitled to a bill of particulars with respect to information which is already available through other sources, such as an indictment or discovery or inspection. So his judge writes, given the conclusion though that only one oath exists for each relevant official, the court doesn't need to reach this argument, so we'll just leave it there. McAfee continues. And just to summarize, there's only one option for each of them, and Trump's team, with a little bit of due diligence, could have discovered the option, learned about the oath, learned that they said that they violated that oath, and so that alone is not enough. McAfee continues. Even if the relevant oaths are apparent as a matter of law, so you can just follow the ball, bouncing ball, go find them, the defense, Trump and co., they further contend that the counts in the indictment do not detail the exact term of the oaths that are alleged to have been violated. Those are big, long oaths. Hands up for a long time. I promised, and the state first responds, right? So what part of the oath? Because you say that we broke the oath, so what part of the oath? Now we know what oath they took, but now we're talking about subsections and they're big oaths. And you need to know that if you're going to defend the case. It's almost like you're asking them to violate another statute. So what part of that other statute? So the state says, you don't need to know all of that. They respond. They say the defense are only charged with solicitation. Okay, so the only thing you need to know about is the asking. So they're soliciting a violation of the oath. So they ask, that's the conduct. Did they have the intent and the action of the ask and the meeting and so-called? That's enough evidence. They say you don't need to know any other evidence about the violation of the oath of office because that's between the office holder and the office. And they argue, so you don't need that information. They argue that the great weight of authority, this is McAfee writing, has never required charging language to reach beyond the elements of solicitation itself. So if we charge somebody with solicitation, asking, hey man, you have drugs for sale, solicitation. Hey, do you want to investigate this election? They say that's solicitation. But it's not about the ask itself. It's only about the consequences of the ask. It's limited to the person doing the asking. It's not about what the person who is being asked does. But they say, so that's what the government said. Fani says, we're only charging with like this little part. Judge says, no, sorry. But Sanders, this case, it tells us that the elements of the underlying predicate felony that is alleged to have been solicited cannot be so easily ignored, right? That's like saying the guy who's asking a guy on the street for drugs, right? The reason that solicitation of drugs for sale is because it's illegal to ask for the drugs. If you solicit him for directions to the nearest restaurant, that's a different situation. So the underlying felony matters. You can't just ask about solicitation in and of itself. It's got to be related to a predicate felony. The judge says you can't ignore that. Not so fast, Big Fani. In Sanders, the Georgia Supreme Court found a special demur should have been granted, meaning indictment goes bye-bye, when an indictment failed to sufficiently allege the underlying felony solicited by the defendant. So they just said he asked for something, but we don't really know why it was criminal for him to do the thing. In particular, for an allegation of solicitation of felony drug possession, the court found that the indictment should have averred the specific drug possessed and its quantity. Well, you're getting charged with a solicitation of a drug, of a felony drug. Okay, what drug? Where? How much? Is it, statutory threshold? Is it a prescription drug? I might have a prescription for that. So what is it? What kind of drug? Sorry, indicted for possession of drugs. What drug? Yeah, maybe I did have drugs, but maybe I had a prescription for them. There's a valid reason for that. Are you talking about Advil or aspirin? Like, what's the drug? What's the quantity? Otherwise, you cannot defend yourself. So without this information, the court said, the defendant could not prepare the defense intelligently, of course, and the crime could be committed in a number of possible ways. Yeah, a lot of different illegal drugs out there. Some have prescriptions, some don't. And you don't even know, where it came from. You say, maybe it's not me, because you don't know what they're alleging, where what it was or where it happened. Now they continue. Now let's back up. They do tell us, however, the state, Fani admits this, that Georgia appellate courts have only considered a single case applying a special demurrer to a criminal solicitation, a case which sustained the demurrer. Okay, so there's basically no case law on this because only Fani could botch an indictment so badly. All right, only the hero prosecutor of America. Now, when charging other compound crimes like solicitation are those which rely on an underlying or predicate offense. And thank you, Judge, for educating the public and us here about what he's talking about. In other words, he knows this is here for public consumption. So an underlying or predicate offense like felony murder. And felony murder, for example, Kate, is often referenced by the bank robbery example. So 4 guys go up, rob a bank. 3 guys go in, give us all your money. Something goes bad. Someone gets shot and killed. Getaway driver, guess what? He's on the hook for murder because he was committing a felony, and in the commission of a felony, someone died. So he gets charged with the murder, even though he didn't even go in the building because he was in commission of a felony. It's called felony murder. And it's a common one. So the precedent says that you got to have an underlying predicate in order for it to be that felony that overlaps onto you. They say precedent is clear that the allegations must either include every essential element of the predicate offense or charge the predicate offense as a separate count. So we know how to defend by getting specific on the elements. In other words, a naked charge of solicitation cannot survive unless it's accompanied by additional elements establishing the solicited felony. So you got to also talk about the drug possession, or in this case, the oath violation. So they tell us, Judge McAfee continuing, he says all 3 statutory oaths that were taken that we referenced, with some linguistic variation, a provision, they all have, a provision that the oath taker will also support the Constitution of the United States and the Constitution of Georgia. And you go, oh man, okay. So Fani is saying you asked an officer to violate their oath. We got to know what's inside that oath. But the oath references the Constitution, and not just one Constitution, but 2. And you have to support and defend and uphold those 2 constitutions. So now we're talking about like a whole library of possible conduct that's covered. Because, the oath could be like, I swear I uphold to like never litter on the street, whatever that oath is. Okay, well, that's it. Okay. He took an oath against littering. That's the only thing in there. So you can defend against littering if that's the example. Obviously, that's not the case. He's referencing some big oath plus the constitutions. So now we have, encyclopedias worth of stuff that we could possibly be charged with. So the indictment, when Fani charged this, when detailing the manner and the means of the criminal enterprise, which is the first RICO count, she describes that Trump and the defendants were soliciting Georgia officials to, quote, to violate their oaths to Georgia and the Georgia Constitution and to the United States in the indictment. And so thus, if you read the indictment as a whole, which the trial court, that's me, Judge McAfee, saying that's what I'm required to do, it confirms that these are the prescribed terms at issue in the 6 challenged counts. So that's all we got. To violate their oaths to the Georgia Constitution and to the United States Constitution. So we have what's in their oath, and how does that oath, and what's the conduct, how does it relate to their oath and to their protection of the constitutions? Now, while Judge McAfee continues, while averments do contain a reference to the terms of the violated oaths, this court finds that the incorporation of the constitutions of both the United States and Georgia is so generic as to compel this court to grant the special demurrers. Gone. Sorry, Fani, losing again. Judge McAfee writes, on its own, the United States Constitution contains hundreds of clauses, any one of which can be the subject of a lifetime of study. Academics and litigators They devote their entire careers to the specialization of a single amendment. And to further complicate this matter, the Georgia Constitution is not just a mere shadow of its federal constitution. And although some provisions feature similar language, the Georgia Constitution has been interpreted to contain dramatically different meanings. And this is in marked contrast with, say, aggravated assault with a handgun, which can be perpetrated in only a limited number of ways, right? Do you have a handgun or not? If you have a knife, it's different. It's not the same statute. So if the defense comes back and says, well, is it a Glock though, or is it a SIG? And if you go, well, that's not specific enough, they say, no, it is. Okay, you know what it is. You can make those arguments in your defense, but at least you know it's a handgun. In only a limited number of ways, and an indictment that merely refers to a handgun is not too vague because it infers that the weapon used was either a firearm or as a bludgeon. So a handgun, right, you use it as a weapon to hit someone with, or you shoot them with it. So the court continues McAfee, throwing Fani's 6 terrible counts out. Says the court's concern is less that the state has failed to allege sufficient conduct of the defendants. In fact, it has alleged an abundance. There's a ton of conduct all throughout the indictment. There's all these overt acts in there. However, that's not the concern. The lack of detail concerning an essential legal element is, in the judge's opinion, undersigned on this opinion, is fatal. Womp womp. Sorry, Fani. As written, these 6 counts contain all the essential elements of the crimes, but they fail to allege sufficient detail regarding the nature of their commission. What was the underlying felony that was solicited? Don't know. They do not give the defendants enough information to prepare their defense intelligently, as the defendants could have violated the constitutions and thus the statute in dozens, if not hundreds, of distinct ways, obviously. Now, under the standards articulated by our appellate courts, the special demur must be granted, and Judge McAfee says, counts 2, 5, 6, 23, 28, and 38 must be quashed. Fani loses. Now, they say the state Fani's office also cited to Wiggins. They say saying that this makes this a closer call, but does not change the result. The indictment in Wiggins may not have listed the specific, quote, crime against the state that the defendant committed in violation of his oath, but it did include enough detail to create a much smaller universe of possibilities, in contrast to the reference in this indictment that incorporates both the entire state and federal constitutions. So it's almost like you just violated the law. Well, I need to know what law. The Constitution. What? What? I need more than that. So they must be quashed, but the judge is careful. He says, so they're quashed, okay? But this does not mean the entire indictment is dismissed. The state may also seek a re-indictment supplementing these 6 counts. So Fani can go back to the drawing board, reconvene that grand jury, and fix this indictment. Of course, that's going to beg the question, how quickly can they do that? And once this new indictment drops with the new charges, Trump's team is going to say, well, we need a lot more time now. These are whole new charges. We just got re-indicted. We need another 6 months to prepare our defense against these new charges, because they're going to be new charges, right? Because these are gone. So it's going to come back and we'll have a second bite at the apple if Fani decides to go this route. Judge says, even if the statute of limitations has expired, the state gets a 6-month extension from the date of this order to resubmit this case to a grand jury. Nor is it inevitable, presuming the state presents the appropriate motion, that the identity of future grand jurors will be publicly accessible. Now, this is an area of law where federal courts have achieved greater efficiency, and one might wish that future grand jurors could be spared this inconvenience for something so easily remedied. Like maybe the law would allow them, right? Allowing the government filing a bill of particulars to inform a defendant of the charges in sufficient details to minimize surprise at trial. But Georgia law provides no option, right? So Georgia says, sorry, like the law says you can't do that. This case from 1988 says a bill of particulars is not a recognized pleading. So you got to do it again. So prosecutors in Georgia have it a little, tough. They can't just slap on a bill of particulars. They've got to go and Fix your indictment. That's why you need experienced people to bring indictments like this on a national case. Maybe Fani shouldn't have hired her boyfriend. Now, alternatively, the state may request a certificate of immediate review. You can appeal this, which the court would likely grant to the lack of any precedential authority. If you want to take this up on appeal, feel free to do it. I'll allow you to. Because what do I know? The courts of appeals should decide this. Because it's a new issue. This is my take on it, but maybe they find differently. Now, defendant Shelley goes further, and he also claims that count 23 also fails because there's no nexus between the offense and the public officers. Now, this court disagrees and finds that the Georgia Senate can play a role in the election contests and that the appointment of presidential electors does relate to their official duties. So the reason that Shelley says 23 goes away is not accepted by the court, even though the count goes away for another reason. Saying, however, these pleading deficiencies do not apply to the corresponding overt acts, right? So there's in the original indictment, there's the charges, and then there's a list of overt acts in furtherance of the conspiracy under count 1. And so they're alleging a broad conspiracy. And so those overt acts like the Raffensberger phone call could be relevant to proving, another part of the case. But this charge in and of itself is not a part of the case any longer. So it could be used for another charge, but not this one. Now, overt acts alleged as part of a conspiracy are not held to the same pleading standards as statutorily based offenses. So conspiracy gives her a little bit more leeway because she can prove the conspiracy with a little bit more evidence. Now, instead, all that is required is a reference to the overt act alleged by the state. And even then, a defendant can be found guilty of conspiracy even after acquittal of any overt acts alleged to have been committed by that defendant, as long as at least one overt act is proven to have been committed by a co-conspirator. So that's right. Conspiracy cases are tough because of that. If you just have one act in furtherance of the conspiracy, that's enough, right? And then you got disavowal and withdrawing from the conspiracies, and it gets complex. But point is, here, the overt acts can stay because she is still pleading conspiracy, and so those don't have to go. Those also don't have to go. Now, there were some questions about whether the phone call was legally recorded, and that's another issue that can come up later down the line, because if the phone call was illegal, then we have questions about fruit of the poisonous tree and whether all of that evidence should be precluded when the case goes to trial, but we're not there yet. This is just even on the indictment, right? The indictment is bad. You have written it poorly, and it's not specific enough to give the defense what they need, so it's got to go. McAfee wraps it up. He says, defendants have not provided any authority requiring that the overt acts go, and so they don't. So their challenge of the overt acts is therefore denied. Those stay in the indictment, even though the charges go away, which is really what those overt acts were in there to go after the charges. So they might use those overt acts for the other charges, but the big one is gone. So ordered by Judge Scott McAfee in a very nice opinion, March 13th, 2024, Fulton County Superior Court. Well-reasoned and a good decision for the defense in this case. Now, there are charges that remain. And so as we see, 6 charges were dismissed. 2, 5, 6, 23, 28, and 38 are gone. Trump still has 10 charges remaining. And let me give you just a snapshot of what these look like. So there's a lot here, but this is how it is broken down. So once again, this is the conspiracy charge. This is count 1. It says all these people were involved in a conspiracy, right? They were all unlawfully conspiring to directly conduct an enterprise, a racketeering enterprise, for the purpose set forth herein, violating Georgia law. We also have this other bundle. So they are bundling up the different documents. So Trump and all these other people were charged with alternate electors violations. So there's another conspiracy to commit impersonating a public officer. So they went and tried to become those alternate electors. So that charge is still active. And then as a result of that conspiracy, there were many other document charges. And so you can see they basically just signed this document, right? This is a felony. So they conspired to file, enter, and record a document. The name of this document was called Certificate of the Votes of the 2020 Electors from Georgia. They said, we, the undersigned, sign this document, illegal. Okay, all of them charged because they were on that document. Same thing happens here, saying that they proffered this forward. That's illegal. Same document, and another charge of the same document by actually submitting it. They used a false document with knowledge that it was false, and they brought that in. They gave it to the Secretary of State. Okay, so they created a document, they signed a document, they submitted the document. Felony, felony, felony. All the creation of that one document creates a conspiracy, so it's bundled up into that charge, right? That's what's left. What else is left? There was another document they wrote. It's about notice of filling the Electoral College vacancy. So here is another conspiracy. And then again, they sign their names to that document. And so that is another charge. We also have Trump submitted a filing in court, which is a crime, according to Fani Willis. So he made the case in Trump versus Kemp. He submitted a motion, a verified complaint for emergency injunction and declaratory relief. So Trump filed a lawsuit. That's a felony crime. That's a charge. He made these false statements, felons voted, underage people were there, individuals, blah, blah, blah. Fani said that's all false and fraudulent, felony. And then Trump sent letters to Brad Raffensberger, 2 felonies for that. So that's what's left. These are all arguments that the election was rigged and that people who are responsible for governing the election should investigate it. So 2 felonies, 29 and 39 for sending stuff over to Brad Raffensberger. Those are the only things that are left, and they're all, largely related to a legitimate investigation that should all be dismissed, and we hopefully see that they will. This is what Steve Sadow said in response to the 6 charges being dismissed. Of course, we've got 10 left, but here's what this sounds like. Here is Steve Sadow. He, of course, is lead counsel for President Trump, doing an awesome job. You should be following him at Steve Sadow on X. He said the court made the correct legal decision to grant the special demurs and to quash important counts of the indictment brought by DA Fani. The counts dismissed against President Trump are 5, 28, and 38, which falsely claim that he solicited Georgia public officials to violate their oath of office, saying this ruling is the correct application of the law, as the prosecution failed to make specific allegations of any alleged wrongdoing in those counts. The entire prosecution of President Trump is political. It constitutes election interference, and it should be dismissed. And Sadow's right about that. We're going to wake up and ask ourselves what happened in 2024 if things don't go our way, and people are going to be looking to election interference and saying, what happened on election day? Whereas we're living election interference every single day here as we march towards November. Here is Jamie Raskin. He was asked about this, and he says that the law is the law, and he's just going to follow the process. Here was his reaction.
That, to me, is a reflection of the rule of law.
Committee who says he's not concerned about the judge's partial dismissal, rather. Listen.
That, to me, is a reflection of the rule of law. I mean, without opining on the specific dismissal, I don't get upset when Trump's team wins a motion in civil or criminal court. That is the rule of law in the justice system.
Yes, you do, Jamie. You're going to be very upset about it tonight. We know you're going to probably introduce some new legislation to maybe decertify another election or something. This is Raffensberger, Brad Raffensberger. Of course, he was the guy on the other end of the phone call, and he was there answering questions from the media. There's a lot of noisy fuzz on this one because they had a cable that was loose. But here is what Raffensberger was asked, not about this recent opinion, but about the 2024 election. Trump's back on the ballot. He's like, oh gosh, Trump again? Oh no.
Yeah, sir, this would be the first time that Donald Trump's name is on a ballot in Georgia since the 2020 election. Given all that you and your family have been through since that time, do you have any thoughts about the fact that by the end of the day he could clinch the GOP nomination for president?
Well, I think it's kind of seeing this all coming down the road. He's been performing well in just about every state. He's won, except a couple. There were several candidates in there, but at the end of the day, he won out. That's how it looks like it's going to end up today. But I'm not making a prediction on that. Just like on the other side, there was a couple of folks that ran against the incumbent president. President Biden, and they all have now suspended their campaigns. So it kind of gets baked in there, as I said earlier, and it is what it is. And now we're just going to have about 7.5 months of campaigning, and I think that's going to wear everyone out, no matter what side of the aisle you're on. It is what it is. You just kind of, well, our job is to really be prepared for a big turnout. Because back in 2020, we told everyone we were going to have a big turnout. We didn't know we were going to get 5 million people. But if we had 5 million in 2020,
or
I
water
don't think
main breaks
changed. I think we still have, both political camps are in their corners, and it's going to be a very contested election. So I expect a big turnout, November 2024. So we're going to probably tell our folks, prepare for 6. We don't expect 6, but we want them, if you did show all up, and we did have 6, would we be prepared for that? So we keep those lines short. I think that was a tremendous thing when we added into state law. Lines have to be shorter than 1 hour. You keep lines short, you get the results posted quickly.
Shorter than 1 hour?
That gives voters confidence, just because, wow, they do things so efficiently. I can really trust the process. Yes, but we also have a verifiable paper ballot. Also, the General Assembly did put in additional audits. We're going to do that. And so we're prepared for any contingency. We've got a great team up and down the line.
No, you do not, okay? Judge Amy Totenberg said it's a disaster over there, and it's going to be madness. Last time they had a water main break that we all remember. We went to bed. Georgia was in the can for Trump. We woke up and the votes went like this, whoop, whoop. And they said, oh, no, you guys are just foolish. That was just the red mirage. Sure, even the news anchors couldn't believe it. So, my friends, good news on the day from the court, Judge McAfee finding that Fani loses again. She's having a terrible showing. Remember, 0 convictions, okay? 4 people took guilty pleas, but that does not mean a conviction. Their cases have been held in abeyance. And as long as Sidney Powell, Jenna Ellis, Kenneth Chesebro, and Scott Hall, as long as they complete their probation, their charges get dismissed. There is 0 conviction. It's as though they never were charged. It is gone, right, off their record. It is a diversion deal. So it's a joke of, it's not even a conviction at all. So that's just a mistake that the other side is making. And we also know that Fani lost big time when she tried to get Harrison Floyd incarcerated again at his bond revocation hearing, and she blew that one too. And they can't even properly indict defendants in one of the biggest cases in this nation's history because they're incompetent. They were too busy indicting each other, flying around Napa Valley, going on their various cruises, and now we can see what's happening as this is all laid out before us. And so we're going to be covering Fani's case and the rest of them, my friends. Hopefully you're joining us and subscribing as we do. And thank you for inviting someone to come over here and join us. Have them come and check out the show so they can see some of the madness going on behind the scenes. We also have some great links down in the description below. Want to invite you to come to an event at watcherlodge.com. Absolutely awesome event coming up this Saturday. Click over to check that one out. RobertGovea.com if you want to download the PDF we just went through. And of course, watchingthewatchers.locals.com, where we have our members-only streams in the morning and Saturday show as well. We'd love to have you join us, and we'll see you back here on the next one. All right. Now, we're not done with Fani yet. We got some more to unpack now that we know what has happened here. The question is, what does Judge McAfee's dismissal of those six counts mean for Fani Willis and the disqualification issue that is still left in his courtroom? We are going to go through some brief analysis. I've got some different options on how I think this could play out. And we'll also hear from Judge McAfee himself. He made an appearance, his first campaign radio appearance, I think this is his first campaign ever, on the Shelley Wynter Show, where he explains more about his background, more about his kids, and why his opinion is going to stay on point, in line with his integrity, not in line with the political circus that's going on outside of his court. We've got reaction from CNN and from Alina Abba coming up on what happened in Georgia with this dismissal. But let's talk about how this could possibly go. So, many different theories. Does this mean anything? McAfee dismissed 6 counts, gone. One of the big concerns that I've seen is that this is just a token victory. First possibility here. It's a token victory. Judge McAfee's throwing a bone to the defense, saying, I'm going to give you a dismissal on these 6 counts because I know Fani Willis is going to stay here. Case is not going to be dismissed, and Fani is not going to be disqualified. Could be a possibility. Now, if that did happen, We've got some other things that we can talk about if my mind map will work. Let's refresh this. We have a technical problem happening here. Hopefully the tubes fix themselves. We refresh this and we ask ourselves, what could happen if Fani is not dismissed? Couple options. One, we have a question now. Would Fani re-indict on those 6 charges? Of course, that's going to delay the case a lot further. Their whole goal behind all of this was to get Trump indicted before J6, before November, and before the election in 2024. That's the J6 case, the Florida case. Both those are off the rails. They called in Fani Willis. They called in Alvin Bragg. They said, accelerate your cases. Fani, we need him indicted on Monday. She got the job done. So this would delay that. The other option would be Fani would just forego the re-indictment on those charges and just continue with this case without those charges to see if even she can get a conviction if she stays on the case. What would the other remedies be? Fani could get disbarred by the state bar. That would take her off the case, Nathan Wade. Now, those processes would probably take years, right? So that would be, I think, something that would not necessarily impact the case. She would return and she would say that there was no disqualification, there was no dismissal. So she would point to the judge and his rulings as saying that she did not commit any misconduct and she should not be disbarred or even sanctioned. If there is an election, Fani may not win re-election, but again, that possibility may not happen if she stays on the case before the election. If the whole goal is to get the election completed before 2024, if she is not re-elected, she might still be in office while this case is pending and even closed. So we have other questions here. What about presidential immunity and the appellate combo? This has been an issue we've been following for some time. This is still a tool that Trump has not pulled out yet in this case. He just pulled it out in the Alvin Bragg case, saying, I have presidential immunity. That's step 1. Step 2, court says, no, you don't. Step 3 is appeal, which automatically results in a stay of the lower proceedings. So that would still be a recourse. And of course, this is another thing that just happened today. In fact, Governor Kemp was signing this new bill into law, this oversight board. In fact, here he is. Looks like he's signing this. And this is an oversight council bill that was signed by Governor Kemp. Signed by Kemp.
Been in here 4 times this week.
And there he is. So this would give oversight over Fani.
It's good to hear.
All right. Well, good afternoon, everybody. Let me just thank you guys for being with us today. Marty and I are proud to be with Lieutenant Governor Burt Jones, Speaker John Burns, a lot of leadership from both chambers of the General Assembly, put them behind bars due to lack of professional conduct. When out of touch prosecutors put politics over public safety, the community suffers and people and property are put at risk. Today we are renewing our commitment that we won't forfeit public safety for prosecutors who let criminals off the hook. Georgians deserve better, and they deserve to feel safe in their own communities. So again, I want to thank Senator Robertson, President Pro Tem Kennedy, Leaders Gooch and Efstration, and Representative Gullett and Gaines for their work on this legislation and seeing it through the finish line. And with that, I'll ask all
right, so they have now passed this council. That council, if Fani stays on, might be something that could take her back off if that is the case. Now, I don't think that this is a likely option, right? We got the bad news out of the way first. I think that Fani is going to get disqualified. The question is, will the case also be dismissed as well? So if that is one possibility, this dismissal of the 6 counts could have been just a token defense victory. It's a small victory in a battle, knowing that we might lose the war later on. Option 1. I'm hopeful that is not the case, and I do not think it will be, but one possibility. Another one. This could be a warning for Fani, right? This ruling is now saying, Fani, we know that this case is pretty problematic, and it's just a precursor to disqualifying her. So in other words, the judge is cleaning up this case for the next DA who's going to come in. The new DA is going to want a clean slate. They're going to want to move with this quickly. This was an issue that was already pending. And so the judge is not intending to dismiss the case, but he's just intending to clean this up, before he passes it off to the new prosecutor. And of course, these rulings need to be made because the motions were submitted by the defense. So he's just following the motions and issuing the rulings. So that could be a possibility. Now, the reason why that might be problematic, or why that justification at least may not make a lot of logical sense, is because the new DA is going to have to consider what to do about this. In my opinion, the new DA is going to see this case and think it is a disaster. So the cleaning up by the judge is not ultimately going to lead to something that is useful or really has any utility, because I think the new DA is going to want to go through this with a fine-tooth comb anyways and investigate what Fani and Wade did, if they did anything. In other words, I think they're going to get an empty manila folder, right? It's going to be mostly garbage. And so you can't do much with garbage if you're a competent prosecutor. So point is, right, one option would be McAfee's trying to clean this up. And the new DA, if they get this case, they're still going to have to consider whether to re-indict on those 6 charges. And again, they're going to have to consider the sufficiency of the original indictment itself. Now, the last option could be that what Judge McAfee is doing is knocking the legs out of the table. Table's got 4 legs on it. He's just knocked one of them out, providing cover for the ultimate disqualification and dismissal. In other words, he's dismissing evidence or dismissing charges showing that this case is not bad only because of their conflict and their perjury, but it's also bad because they don't even know how to indict people. Okay, like these 6 counts have to go because it's constitutionally vague. We don't even know what the charges are. So that's just one leg of the 4 on the table that he knocks out. The other is going to be coming soon. He's going to disqualify Fani and Fulton County and then ultimately dismiss the case. Now, Fani would then appeal that. And also, if he lays these both down, right, Fani might be appealing both issues. And if we think about the appellate layer to this too, that adds a whole layer of complexity. So what if, because I think both sides will be appealing, if judge does not disqualify Fani, they'll appeal. If she does get disqualified or the case does get dismissed, Fani will appeal. And let's think about it logically. So if Fani gets disqualified, then Fani would come back, have to appeal the disqualification. And then when that is rectified, then she's got to fix the deficiency in the indictment. And there is no way that happens before the election. Absolutely no way. So the indictment adds another layer of analysis and some more complexity to this. Now, the right legal answer, I think in the court of law and in the court of public opinion on all of the issues is disqualification is appropriate and dismissal is appropriate, because the misconduct that was committed by these prosecutors went all the way back to the original indictment. Their affair started in 2019 before the appointment of Nathan Wade. He got appointed on November 1st, divorced his wife November 2nd, because he was already indicting Fani. They had a relationship well before all this started. So in addition to that, they lied to the court, which, again, the only sanction that you can properly pursue against a prosecutor is dismissal. You can sanction them, you can fine them, but it's the government. It's just government money. So the real remedy is a dismissal, and a dismissal on this would be a big one. So here is what Judge McAfee sounded like. He went on the Shelley Wynter Show, and he was asked about a lot of these issues. And let's listen in and see what he said, because he is now campaigning. And of course, if you're in Georgia and you like what you're hearing for Judge McAfee, well, you might be able to support him in his campaign, because he's going to be fighting a very, very serious uphill battle. Here is what his interview sounded like from the Shelley Wynter Show.
Yeah, absolutely. They can get on board at keepjudgemcafee.com. And so if anyone cares about our criminal justice system and making it better for everyone involved here in Fulton County, I'd ask for them to take a look, to join us. I'd ask for their vote and for their support.
You were handpicked and selected and put in that position by Governor Brian Kemp. So this is your first election that you've ever run, or have you been in other elections before?
No, this is the first time, and I'm looking forward to getting out there.
Last night I had which is now I guess your challenger, Robert Patillo, on, and one of the things that he talked about why he's running is because of the backlog of cases that he says the judges can help out. Criticize the fact that this case, this what we call election interference case with Donald Trump and 18 others, has moved through the courts very quickly, but there are people who are sitting in holding cells and in Fulton County Jail who have not seen a judge, and he's saying that's why he's running. What do you say to that?
Well, what I would say is that a lot of what he shared with you yesterday about efficiency, about getting everyone their timely day in court, I couldn't agree more with that. He's absolutely right about that, but he's coming after the wrong judge if that's what he really believes. And frankly, I've got the numbers to prove it. I mean, from day one, my job was to attack the backlog, and I've done that with everything I could, and it's working. I mean, I can tell you that I inherited a docket where I was second to last in terms of the number of pending cases. In 1 year, I'm now in the top half. I'm number 6. I had 53 different murder cases when I came on board. We're now down to 25.
That's a lot.
We had 25 defendants that had been sitting in jail for over 1,000 days. We're down to 10. So we have...
Those are great numbers. And honestly, of course, I subscribe, and I'm sure many of you do too, to Judge McAfee's courtroom YouTube channel. And I see the activity in his courtroom. I go there, I check it. I say, anything happen interesting here in McAfee's courtroom? He's got a bunch of other cases going on. He was just in a jury trial, right? So not only is he managing a monster 19 co-defendant RICO case with all of the filings and the pleadings and everything that's going on there, but he's also still conducting jury trials for murder cases. Like, it's a big deal. And he's handling a very, very grueling docket, and he's handling it very nicely from our perspective.
I've been attacking this backlog with everything I've got, and we've been just doing jury trial after jury trial. When you reached out to me yesterday, I just wrapped up another murder case. So all I can tell you is people maybe don't see all of the cases that I handled. Maybe one of them gets most of the attention, but the actual bread and butter of what we do and that's happening in 5A is exactly the type of work that he talked about, and that I'm really proud of.
And was that your stated goal when you got put in that position by the governor, was to take care of the backlog and get people moving?
Oh, absolutely. I mean, that has been one of the most continual frustrations of Fulton County. You know, you've got a case where a victim's family is just sitting there waiting to try and get some justice in the case. And on the other side, you've got a defendant who oftentimes just, again, wants his day in court, wants to tell his side of the story, and they're just sitting there waiting. And we've got to have a system that recognizes that and people willing to put in the work to make it better. And we've got the resources, we've got all the means in Fulton County to make that happen. It's just a matter of knowing how a courtroom works, having spent a career in a courtroom, and knowing how to move those cases along, and that's exactly what I've done.
One of the other criticisms that Mr. Patillo logged last night was the fact that many judges come from the prosecution side, and
that's
so
true.
You, as a defendant, you're up against two prosecutors in effect. What do you say to that?
Yeah, and I've seen that. I've seen a lot of judges who were prosecutors, and not as nearly as many who are defense attorneys. You know, defense attorneys kind of go private sector, and the prosecutor hierarchy, you know, you become a prosecutor, you go there for 10 years, get your student loans taken out, then you decide you're going to, level up, you become a judge, you have multiple rotations, and that's kind of your career path. But a defense attorney is not, right? Defense attorneys kind of go into private practice and spend their whole lives there. So we see a lot of prosecutor and prosecuting judges, and I've seen, in my opinion, it always feels like the judges are biased against the defense. I think there's an institutional bias against the defense. But I have also seen judges who were prosecutors who I would feel, just anecdotally, would overcompensate for their prior careers as a prosecutor. You know what I mean? Like they would almost give the defense a little bit more grace by default because they knew that a stark criticism against them was that they were a prosecutor. So in other words, they would be, fair, whether it was natural or they would give the defense a handicap to give over, because of their prior careers. Who knows? But you can still see fair judges even despite that background.
So, certainly he's right that a lot of judges do become or start out as prosecutors. I certainly spent plenty of time as a state and federal prosecutor. And a lot of when you're looking at someone and a lot of what that job is, prosecutor's job that's done well is almost quasi-judicial because you're not just looking out for your own case. You're not winning at any cost. It's about justice over convictions.
Okay, we'll be nice to Judge McAfee because that's the right standard, but that's not what many prosecutors believe in their hearts. Many prosecutors, like Fani and others, are about convictions first and foremost. And I've met many prosecutors that don't care. I've shown them evidence right in their faces. And they just, well, my cop says differently. I go, your cop's a liar. And they, well, whatever, right? They don't care about, they're just moving through cases, moving through numbers. You know, they got a big, backlog and they don't really care. They just want convictions and that's it. So, this judge is giving a political answer. And honestly, it's kind of a shame that he's got to explain himself in this way, because he's facing, I think, a purely political attack from the left. Nobody was running against this guy until Fani got outed as having an indictment with her lover. Then we better get a candidate up there, right, to put some pressure on this to not disqualify her. Came out of nowhere. It's a political attack, obviously. So he has to explain his prosecutorial background to a very, very blue county who probably don't like prosecutors all that much,
So oftentimes as a prosecutor, I was looking after the defendant's case because I didn't want it to get overturned on appeal. So that mindset as a prosecutor,
good
like
answer.
I said, it's very similar in some respects to what you're doing as a judge. So that transition from a prosecutor to a judge, the right kind of prosecutor, is one that I think is very much speaks to what a judge is supposed to do in terms of seeing the bigger picture. And it's one I've tried to apply in every case in terms of approaching a case from a perspective of allowing both sides a fair day in court. So I certainly think he's entitled to that perspective. But when you actually look at the work I've done, I think you'd be hard-pressed to find any attorney who's tried a case in my courtroom who didn't think they got a fair day in court.
We're on the phone with Judge Scott McAfee,
I think that's
Fulton
fair.
County Superior Court judge, and has a challenge for his election, and that election is in May 21st. Let's go a little bit to the big election interference case. I do have to ask you this question. Do you feel that Petillo's run is being backed by Fani Willis, which a lot of people on my
Yes.
side of the fence and a lot of people I've spoken to feel that this is a pressure campaign
Yes.
to force you to, and I'm doing air quotes, do the right thing or make the right decision. Do you feel that way?
No, I couldn't tell you that. And I haven't met him. I haven't seen him around the courthouse. And like I said, I think he seems sincere. So I'm not the type that I'm going to presume the worst of that sort. And
What a nice
I'm not one to
judge.
jump at conspiracy theories like that. And the biggest thing that I wanted to come on and make
Not a
sure I told
conspiracy
you today that even if it is, it doesn't matter because it is absolutely not going to play into my decision in any way. No job is worth my integrity.
Boom.
And, when you ask that question, what I think about is, I've got 2 kids, 5 and 3. They're too young to have any idea of what's going on or what I do. But what I'm looking forward to one day is maybe they will grow up a little bit and they ask me about it. And I'm looking forward to looking them in the eye and telling them I played it straight and I did the best I could.
Wow.
Very nice.
That's a strong.
Very nice answer.
Editorializing here. That's a strong answer right there, and I know it's true. So on that side, can you tell us?
And again, we're asking ourselves about the court of law and the court of public opinion, right? This guy is a judge. He wants a career as a judge. He's doing the job of a judge. The job of a judge is a sacred position. It doesn't work without a good judge. And the judge, a big part of their duty is to keep decorum in the courtroom. And if you have people lying to you, committing perjury, committing felonies in your own courtroom, that is a whole different, that's a whole different justice system that we have here. If Fani and Wade can get away with that and Terrence Bradley can get away with this, that is so beneath our justice system, and it's beneath the integrity of what he signed up to do, right? It's a sacred honor to be a judge. You send people to prison for a long time, if not the rest of their lives. It's a very powerful, position, and so we need people who take it seriously, and he sounds like the type of guy who does.
So I have got to ask this question also. Can you tell us, are you any close or anywhere closer to that 2-week decision on the election interference? Are we closer to that? Are we sooner than 2 weeks or outside of 2 weeks? How are we looking?
I gave myself a deadline because I knew everyone wanted an answer. And I'll tell you, an order like this takes time to write. There's a lot that I have to go through. And so, I'll emphasize this. I've had a rough draft and an outline before I ever heard a rumor that someone wanted to run for this position. So the result is not going to change because of politics.
The results are not going to change. So the outline has been drafted for some time. And we know that guy, Robert Petillo, just announced pretty quickly after the closing arguments. So he may have already had that started outline before those closing arguments were even completed. So what does he have in mind?
I'm calling it as best I can in the law as I understand it. So I still feel like I'm on track to having that done by the deadline that I put on myself.
Today, the news broke that the
Friday,
Fulton
we're
County
waiting
Commission dropped any ethics hearings with a DA against DA Fani Willis because she's a constitutional officer. That was one of the arguments waged by the defendants when you had the hearings. Does that change anything based on your outline and what you've been thinking about in your decision?
Well, Shelley, unfortunately, I think that's where we start dipping into that realm of commenting on a pending case.
No problem.
So those judicial ethics prevent me from doing that, but maybe we can sit down many years from now and have another conversation about it.
No problem. I had to ask.
All right. So great interview from the Judge McAfee, and that came over from the Shelley Wynter Show, a local Georgia radio show. And I thought it was a great interview. I mean, he seems like a very stand-up guy. I like that he was talking about his kids. I like he was talking about, the efficiency of the court and how he's doing a good job to work through it. And it does require a judge to work through it, right? There are different types of judges, just like in any profession. You might show up to, a doctor's office and it's run in total disarray. Everybody's late, appointments are behind schedule, doctors, shows up late, not prepared. Who are you? Why are you here? Whatever. Or you might, have a well-tuned, finely tuned machine. You go in, out, you're like, dang, they knew everything. Do judges read their briefs before they show up? Are they prepared to go? Do they know the case law better than the lawyers? And can they manage the courtroom? Judge McAfee certainly can. And now he is being challenged by a pressure campaign from the left to try to get him out of office or to get him to correct what they think is an injustice brought against Fani Willis. But Fani Willis is an embarrassing lawyer. She's been embarrassing for a long time. Now more people are seeing it, including CNN. Elie Honig was asked about this, and on the radio on CNN, he was commenting about how much of a mistake this is out of Fani's office.
Trump and Brad Raffensberger, where Trump asks him to just find 11,780 votes. We've all heard it many times. That is still part of the case. That phone call is still part of the case. There are other charges in the case that squarely relate to that phone call. For example, the first count in the indictment, which is the very broad racketeering count, will still include that conduct. There are other fraud counts that would still include that conduct. So I don't think this ruling changes the type of evidence that the DA is going to be able to introduce, but it does knock out some of the charges. And look, it's embarrassing for prosecutors.
Yeah.
It's a screw up by prosecutors when you bring a charge and then a judge throws it out before it even goes to trial.
Well, and that leads me to this question, Elie, because there was so much was made of Fani Willis and her handling of this case, and the hearings that we saw play out on live television was such a spectacle. Does this bolster, in the judge's mind, the idea that perhaps the Fani Willis should not be handling this case, or is that a step too far?
It should not bolster the conflict of interest argument. I think these are and should be seen as two entirely separate questions. The question in the decision that we just got is the indictment properly constructed? Were these charges properly put before the grand jury, and are they sustainable? And the judge said, with respect to 6 of the charges in this case, again, not all of them, but just 6, no, they were not properly brought. There is an entirely separate question pending where we're waiting for a ruling any day now, where the judge has to decide whether the DA has a financial or other conflict of interest relating to her relationship with the outside person brought in to be the lead prosecutor here, Nathan Wade. Those should be completely different questions and completely different considerations by the judge.
I think that's probably right. I think he's probably going to consider them separately, but you can weigh into them. You can, I think, read into them some propensity, right? He's okay dismissing charges against Fani, that's for sure. Is he willing to dismiss the case is another issue. Now we finish our segment with Alina Abba. She showed up on Fox. She had a nice interview, and she was explaining some reaction to what's happening in Georgia. Here she is.
What's your reaction to what happened today in Georgia?
I wish that all the counts had been dropped, because that's probably what should have been. I mean, at least it was a step in the right direction. It goes to the sloppiness of, frankly, the prosecutors down there. We know that that's the case. And more importantly, that this should not have been brought in general. The attorney handling this case put out a statement that I think says it all. And at the end of the day, remember, we've got a prosecutor here who's currently being questioned about her own ethical obligations, her ability to even stay on this case. I'm going to defer to this judge to make the right decision, but today was a good step in the right direction.
What do you think it means for whether or not he will decide to remove Fani Willis from this case? What does your gut tell you on this, Alina?
Fani's gone.
I don't think it's indicative necessarily of his actions in terms of Fani. I think that Fani, whatever she calls herself, she's got her own issues that are outside of this case that clearly have permeated her decision-making ability. And as I've always said, as my clients always said, we know that these were motivated by one thing and one thing only, and that's election interference that's trying to bring Trump down. And on the heels of last night, I think that it's very clear that the American people are seeing it for what it is and are going to stand up and not take it very much.
I want to get your thoughts, even though you're not directly involved in this. You're part of the larger legal team representing the former president. But the first case that is set to go to trial is in New York City here on March 25th under Judge Merchan. And it deals with the hush money that was paid to Stormy Daniels. That's what the charge is in this case, and that it was diverted in the way that it was paid through legal fees. Do you think that case is going to get underway on March 25th? And how does the former president feel about this one that is likely to happen before, right in the middle of the election season?
Yeah, it's coming up. And Trump and we covered this recently, is trying the immunity combo where he says, I'm immune, judge says you're not, then appeals it, and the appeal stays the lower proceedings. So that is already underway right now.
Yeah, it's a couple of good questions there. Number one, do I think it's going to go ahead? Well, really, it shouldn't. We have an immunity defense that's currently up on the Supreme Court. It's going to be made a decision. It should be stayed until all of those decisions are made, number one, and we'll see what happens there. Number two, let's remember what this is, Martha. Stormy Daniels is probably one of the oldest legendary let's get Trump cases that we saw come out. Her attorney, I believe, is in prison or was probably disbarred. Michael Cohen yet again reared his ugly head in that. And here we go, years and years later, they decide, guess what? He's the GOP nominee. Let's bring up this case again. We have Mark Pomerantz, who was in this case involved, wrote a book about how they didn't bring the case against President Trump, and it infuriated him and drove him to the point of quitting. This is all about politics. How does the president feel? I think exactly that way. This is political. There's no place for this in America. DAs and AGs should not be visiting the White House and the administration before bringing complaints against the leading front-running candidate for the Republican Party because Joe Biden can't walk and can't spell Bob backwards. That's not our problem. That's their problem. But it's very clear what the motivation is. And I think the president's frustrated for the nation and ready to get back to work in November.
Nice job, Alina. Alba in the house. And so, my friends, of course, we are going to be here patiently waiting to see what Judge McAfee does in the RICO case as he continues to write his ruling. And we're going to be here covering it, not only this case, but the rest of the Trump litigation that is currently underway. And we've got New York coming up. We've got Florida updates. There is oral arguments in Florida tomorrow. So we're going to be here covering it all. Thanks for subscribing. Thanks for sharing our channel with a friend or family member, inviting them on over here to see what's really happening in these cases. Of course, we also invite you to check out some of the links down in the description below. Any PDFs and our daily newsletter is available at robertgovea.com. We have great events at watcherlodge.com. Come and join us. We'd love to see you this Saturday, absolutely all free. We also have watchingthewatchers.locals.com, our members-only community, where we do streams in the morning and on Saturday, and we'd love to see you there. And, of course, right back here on the next one. All right, my friends. Well, that is it for us on the day. We covered some good ground, some analysis on what's happening with McAfee and the dismissal. I think he gave a great interview. Seems like a pretty stand-up dude. Whatever way this goes, he seems like he is solid. Fani loses again. 6 new charges dismissed, gone. And one of them includes the perfect phone call between Trump and Raffensberger. And so now, my friends, it's time to hear from you. Let's see what you say about this before we wrap it up and go over to our members-only after party on Locals. But who is here on this beautiful day? It is an amazing day. And Glocky's getting us started here. No, yeah, Glocky. Hey, Viva had a great interview today. Shout out to our friend Viva. If you guys aren't following Viva, you should be. He's right next door, Viva Fry, on YouTube and on Rumble and on Locals, vivabarneslaw.locals.com. He says, Viva had Jeffrey Clark's attorney on for an interview about 2 hours ago. Whoa. And Jeff Clark's attorney said a new law in Georgia is that if the DA gets disqualified, then the entirety of the DA's office is automatically disqualified from prosecuting the case. And I think that's true, absolutely true. And it will take off the whole Fulton County. They're gone. Somebody else would have to come in. Glocky says the Democrats have the courts, the federal police, and now the military. They're now openly talking sedition and treason in the Pentagon. If you aren't scared about what's about to happen, you bloody well should be. Interesting comment there from Glocky, and I think very good advice. Yeah, they're circling up for something. Pritchie's here. What's up, Pritchie? Says, my opinion is he is defanging the snake, so to speak. I like that analogy. So that when he disqualifies them in Fulton County, the next DA goes, not a chance am I taking this on. But if they decided to go ahead, the phone call can't come back as illegal. Defanging the snake. So almost like knocking out the leg of a table, right? You're slowly whittling away at the case just bit by bit. So in other words, when he comes back out and they say, you disqualified this only on a conflict of interest. No, it was also, the indictment was also, she couldn't even write 6 counts in there because she's so bad. Pritchie, what's up? Bringing in 5 membos. Pritchie, thank you. Catania Mama Italia's coming in. Tom F, Saintly B, Barbara J, Maureen, all coming in courtesy of Pritchie 26 in the house. Hey, what's up? K-Jab is our newest supporter on the YouTubes. Welcome, K-Jab. Here's one. For anyone who has a TDS friend who needs some instant relief, just give them a little bit of Trumpazine. Trumpazine, 24 caplets, 24-hour day, maximum strength, liberal suppository. It's going to give you freedom from your fake outrage. Just put them in your rectum. Donut. Hey, Donut, mind me. Thank you for clipping this. Okay, so this is a great comment from Crash. And Crash, we're going to come back. We're going to save that one for the end. Pritchie is here. Gifted 5 membos. Bourne is here. Brian B. Bob D. Freed is here. Pinochet's Helicopter Tours. And D. Gillis all got gifted more membos courtesy of Pritchie. Glocky McGlock says, Trump was literally helping stop crime in D.C. Donald stops an attack. Call it the Donald to the rescue. A mugger got trumped. A bat-wielding thug takes off. Not in my city. That was until Tishy came in. Hey, more membos from Pritchie. Pritchie, so generous. Thank you. Check it out. We got Haluja Talachek is here. Angry Viking Veteran. Tom G. Rodney's here. Robert T. We got Sassy T. Mr. E. Randy V. Theon L. And Toneil H, all coming in courtesy of Pritchie. Thank you, Pritchie. And Bourne says, thank you, Pritchie. Very grateful and welcome aboard to our newest of membos. We got this one from Glocky. Says, Facebook took this down. Keep it up. I love it. Too funny. Hillary Clinton says, I would like to see people like Donald Trump run for office. They're honest and they can't be bought. Hillary Clinton. Yeah, regrets those words. Hey, more from Pritchie. Pritchie, my goodness, is bringing in Dixie Mafia, Cool Comic Guy, Greg E, Eric L, Tyrannus Cygnus, Stephen E, Toodly Pip, Memo, Philip H, Paul, insert last name here. Also are all joining us courtesy of Pritchie. Amazing. Londo's here. Says, hey, Rob, hey, spent the last 2 weeks going to Phoenix each day. Gotta break it to you. It stinks. Don't know how you can live there all the time. Move to Ahwatukee or Apache Junction and get some peace. It's good advice. Thank you, Londo, for the advice. Yeah, I totally hate my life. It's terrible. Catania Mama Italia says, smash that like button, baby. Hey, Wims. What's up, Wims? Wims is in the house. Wims, so good to see you. It's been ages. A membo for 7 months. Great to see you, Wims. Almost 2 months away from a baby. Says, I'm home early enough for a show. It's a good day. It's a good day indeed, Wims. Good to see you again. Hopefully, everything in your life is incredible. Show Bizzle says, hi, friends. Rob, I really would like for you to explain something to me. At this point, isn't it almost counterproductive to continue to bring in witnesses if they are always going to either lie or say, I don't have that data with me? I'm not suggesting that we give up by any means. All that I'm saying is that doesn't that just give them more power on the taxpayer's dime? I would love your thoughts on this. So Show Bizzle, yeah, I think you're actually right. I think at some point the judge is going to call a lid on it. Okay, I've heard enough. I've already got my decision made. I don't need to hear any more. So we're not going to keep carving this turkey. We're not going to keep filleting witnesses out there and rubbing the government's nose in this. I've heard enough. Now, by contrast, the taxpayer dime, I think, is being served personally by rooting out corruption like this. So I think that's the least of our concerns. The entire prosecution, by the way, is a waste of taxpayer dollars. So if we're going to invest some money in figuring out how corrupt Fani and Nathan are and save ourselves another, $700,000 going into Nathan Wade's pockets, I think that's a little bit more fiscally conservative for the Georgia taxpayers. But yeah, eventually it does wear out. The judge gets tired of hearing it, and he closes it. We move on. Pritchie, what's up, Pritchie? We got Trump with the blue tie. I'm still working on the red tie. We're working on that. 1 month, Pritchie, as a membo. And it's G-Gum. G-Gum, it's working. Says, oh my gosh. Don't know how I did it, but I navigated to somewhere and was able to log out of the locals beta version. I'm able to upload a meme. I can't believe it. It's working. We got Alina Abba is back. Oh, hi, Alina. How are you? Nice to see you here. We have Patrick Parker bringing in 5 membos. Maddie A, Scott P, Piper L, W Daisy Girl, and Glenn C coming in courtesy of Patrick P. We got This Is Here from Glocky says, his dad will pardon him even if he somehow gets convicted in federal court full of Democrats in California. Okay, so Hunter's trial on June 3rd. I doubt it. They'll postpone that. We got Mr. E. What's up, Robert? You're charged with breaking a pinky promise. Did I? That's a big deal. Isn't that the death penalty? 11 months, Mr. E. 11 months. What did we pinky promise on? Kind of sounds familiar, but I don't remember. I'm a terrible pinky promiser. CGI Joe says Patricia P is, whoa, we got 10 membos. Patricia P, Greg E, Bruce L, Chris K, Eric K, Taylor, L, Leonardo. We got Brian W, SJ, and Castro Valley, all here courtesy of CGI Joe in the house. Chris 1 is bringing more membos in. Thank you, Chris. Very generous. Susan D, John J, Sergeant D's here. Welcome, Sergeant. Jittery Hobo is in the house, and is TK coming in. Thanks to Chris 1. Thank you, Chris, for bringing in 5 new membos. Jennifer N, what's up? This working out pair says keep it up. And he looks like he's doing bicep day. Thank you, Jennifer. Pritchie says, sharing the love. Enjoy the extra shows, guys. Very nice of you, Pritchie. Yeah, we do live streams in the morning. So you may have missed us this morning, but this morning we talked about the Fani Willis stuff because it was fresh out of the oven as the show was starting. So if you want it extra fresh in the morning, come get it at watchingthewatchers.locals.com or on YouTube as a membo. And thank you, Pritchie, for being so generous today. Kevin G, what's up, Kevin? Welcome in to the membos. Barb's Loves Alaska's over on Rumble says, the judge threw the balls into Fani's court. So, who, Nathan's? So will this new finding by Judge McAfee make Fani a decision for herself to drop the case and just walk away instead of being removed? No. Fani, it's a nice idea, Barb's Loves Alaska. You're talking about somebody with honor and integrity who cares about their personal reputation, not Fani Willis. She doesn't care. Fred Pedamonte is here. Says, it's a SIG, okay? If it's a Glock or a SIG, it's a SIG. Great show. Johnny says hello. What's up, Johnny? This little rascally dog here is named Johnny, and he's responsible for nuclear proliferation in this world. Sean Collins, what's up? Welcome aboard, my friend. Newest membo on the tubes. Welcome aboard, Sean. We got Bravo Tango Whiskey. Says, Robert, great daily content and breakdown of these and other cases. Thank you, Bravo. Very nice comment. Nice dono. Thank you for being here and saying that. We have fun. We have a lot of fun together. Hey, Fractal Machine says the reason they're charging Trump is because they want to preemptively make his claims look ridiculous for when they rigged 2024, as they did in 2020. Yeah, so they're just going to say, see, he's doing it again. He's trying to steal another election again. He already did it once. Now he's doing it again. And you go, oh, gosh. It makes total sense. Fractal, thank you for that. And what is this dono currency? That I've never seen before. Thank you, Fractal Machine. I don't know what that is. Yeah, we got this one from Jennifer. It says, each county in the U.S. has to allow election observers. Please be there in November watching the Watchers, fam. Common sense needs you. It's a great plug, Jennifer. And we had somebody on, Sadie from Locals was out canvassing the other day and was sharing that with us too. And I think it's great when we're involved. And we're dragging everybody we've ever met and known to the polls to vote appropriately. Local support says we've submitted a fix for the chat not updating. It's been released for the Android app and iOS should be available. So make sure you update the app and it will resolve it. Amazing, amazing. Locals is fixing things rapidly. Bodie says, what would the perjury charges do for the case? I think he'll dismiss the case and recommend all 3 of them for perjury charges. That would be real justice. They would be charged with new crimes. Like he'd recommend that to the AG or maybe this new committee. I don't know what this new committee is going to do, but maybe this new committee would have some involvement in that. But yeah, I think that the perjury charges would be new crimes. They would be separate and apart from the dismissal. So the case would be dismissed. They would be charged separately in a new case. Pinochet says, wait, court isn't like a Law and Order episode? No, Big Fani didn't get that memo. And that's why she got obliterated during that bond revocation hearing. Jigam says, I'm very glad that I'm out of the Locals beta version and that I'm finally able to give Rob and the Watching the Watchers team a dono. Jigam, you're super generous. I'm happy we got it fixed. I know there was some frustrations there, and I'm glad it worked out. So I'm glad it's working. And shout out to this beautiful kitty cat who's saying hello. Hello, kitty. Hello, little kitty. Pinochet says, can any inference be made from the amounts of objections the state made that were overruled after the in-camera hearing? To me, he seemed annoyed. No, I mean, you have a right to object, and I don't think he can say you're objecting so much because you're engaged in a conspiracy. But anyways, to me, he seems annoyed. I think you're right about that. He was annoyed, and I think he's tired of the evidence. Former says, Rob, I thought that Willis and Bradley were dedicated, reputable, and honest defense attorneys. Rob, your bias is showing again. I'm not real sure what that means. Did I ever say that Willis and Bradley were honorable defense attorneys? E. Harris says, has Rob discussed the TikTok bill that openly allows bans for national security? I saw a note elsewhere that said the bill is way too broad. No, I have not talked about it. I don't know that. I think the House already passed it. I was going to say, I don't think many people have talked about it. They just kind of shoved it down our gullets, and we're going to see what the Senate does. But yeah, I think that it is probably broad. And if a bunch of Democrats are in favor of this without even reading the bill, I'm not. Catherine Rex says, RNC filed a lawsuit against Michigan. I saw that. Did you see that? Yeah. So the RNC, man, they get a little changing of the guard. They're already filing election litigation. And it's good. They need to. They're asking Michigan to clear out their voter rolls. Mark Elias was freaking out about that today. And it's good. It's good. Finally, we have some legal action now that's happening because the Democrats did this all throughout 2020. Jennifer says, thank you for playing Judge McAfee on that clip. Oh, the Judge Mercan is now Juan the Snake Mercan. Please, Sunflower. Thanks for another great show. Please. Yeah, Sunflower. Thanks for another great show. Thank you, Jennifer. Yeah, Judge McAfee on that clip I thought was very good, right? Kind of humanized him a bit. We got to see a little bit behind the curtain, behind the robe, and I thought it was good. Glocky's here says RFK Jr. has a pretty interesting lineup for who he wants to be VP. Aaron Rodgers, Mike Rowe, Tony Robbins, Tricia Lindsay, Senator Rand Paul, Tulsi Gabbard, Jesse Ventura, and Andrew Yang. Okay, that's an interesting list from RFK Jr. It's an interesting list. We got David Harden says, can McAfee demand an invoice or a billable prove up? I suppose he could. There'd be objections to it. And Yeah, I mean, I think evidence is closed at this point. But are you asking, could he demand that Fani and Willis prove, get evidence? I mean, if he thinks that they lied to him, if he says, okay, you said this and I want to see this, I think he could say that. I think there's a crime that's been committed in my courtroom. So you're ordered to demand, I order you to go produce this because there's a crime in progress. We got Felix says DEI, Bush League, Fulton DA lawyers. Yeah, some of that's going on. Pete Smith says, hey, Pritchie, what about me? Stick around in the chat, Pete Smith. Those membos are dropping. We got very generous membo gifts today and always. We got this one from Lao Su, member for 9 months. Whoa. We got a baby in the house. Says, Rob, check out the lead attorney. I have. He's got a great channel. Yeah, I saw him and he's talking about a lot of this stuff. So shout out to our friend, the lead attorney. We haven't crossed paths officially, but I checked his channel out. Somebody else mentioned it and he's doing great work on this stuff. Jackie Carrion says, I don't live in Georgia, but I'd contribute to McAfee. Right? He sounds like a stand-up dude. Depending on how he rules, he might have some really good reasons for it. We'll see. I think it's not going to be in Fani's favor. It was really bad. Hey, Tasadaka on Local says, I was aware Jack Smith was a partisan hack. I didn't realize that he was a part of the IRS attack against the Tea Party and other conservatives under Obama. Yeah, and he got overturned by the Supreme Court 9-0, right? So he's a deranged thug, like literally. Hey, Maya, thank you for this. Says just a little something to say thank you over on Rumble. Thank you. Maya in the house. Very nice of you. Appreciate you watching on Rumble. We got Bobby S. says, bring back what they did in the revolutionary days, says Bobby. We got Squid says the price for breaking a pinky swear is becoming a county prosecutor. No. Just throw me overboard. Okay, I can't do it. Jeffrey Adams says, Rob, is there a way to do super chats on X? I don't think so, Jeffrey Adams. I don't think so. Not yet. Elon is working hard on a lot of the video content and how that works on X. So maybe one day, but not currently. But thanks for asking, Jeff. And Wendy Ty is our newest supporter. Welcome aboard, Wendy Ty in the house. And so thank you, my friends, for sending all of those in. Let's say hello to our friends on X and see who is watching us over on that amazing platform. See if you're joining us over there at Rob Govea ESQ is the location. And anybody joining us? Who dropped some comments? We've got some good ones. Salty Sarge, what's up, Russ? Says the judge giveth and the judge taketh away. Says Judge McAfee also stated that the quash charges can be refiled, as we saw. Good comment, Russ. This one was about Hunty. Salty says that asking whether the laptops match hers document. Billy Jones is asking, if Fani's taken off the case, does that mean she can just retry the 6? No, she would be separated from the case and the case would move forward. Says the defendants were petitioning their government for a redress of grievances. Yeah, asking them to go in there and investigate a rigged election. Nothing criminal about that. Fred says, am I wrong? Didn't I read that Fulton County said they did check a single signature on mail-in ballots? Maybe didn't. I don't know. I think that I don't think it was that broad, but there was some that they think did not get signature checked. Fani Willis, says Sandra. What's up, Patricia Fleming? We got Raven Madness. Crypto Nerd says Texas is watching. What's up, Ryan V? Says Big Fani's not entitled to raise the burden of proof in these cases. Absolutely not. Salty's here. Says the New York Post articles filed by Miranda Devine has the document in there. Kat Ryan's here. Yeah, now the left can't scream 91 felonies. Yeah, now what do they say? 88? 88 felonies. Has a different ring to it. What's up, Captain? Says, I'm going to drop off tumblers at the post office tomorrow, Rob. Love what you do. Whoa! Well, I guess I'll go to the post office tomorrow. Thank you, Captain. Very generous of you. Thank you for that. Captain made some very cool tumblers with the logo on them. And a source familiar says, how soon before he rules on Fani and Nathan? Yeah, tomorrow or Friday. It's coming out any minute. And Vientika says, get your guys' wallets ready for Monday. Is that when your book's out, V? All right, Vientikas' book coming out on Monday. Get your wallets ready because it's about to get enchanted. Now, we are going to wrap it up, my friends. I know we had a couple other donos come in. What's up, Pritchie? Some more membos? Oh, my goodness. Says Mother of P is coming in. Greg M, North Star, Frank B, and David H all coming in courtesy of Pritchie in the house. Thank you, Pritchie. And Angry Bellsprout says, imagine if Georgia said the date can be, I don't know, the 90s, I guess. Well, then they would be like New York, right, with E. Jean Carroll. When did you get Bergdorf in the dressing room at Bergdorf's, E. Jean? She's like, I don't know, 93, 94, 95, whenever. That would be what they're doing in New York. And Former says, if RFK Jr. is on the ballot as an independent, whose vote would he dilute? Good question. Yeah, good question. I think probably more of Biden's, personally. Dan Sundin says there was 0 signature verification in all of Georgia. Dan Sundin, who gives us some very good information on Georgia over on Locals, says 0 signature verification. Sounds about right. Yeah, because they're not doing a good job at much else there. Michelle P says, Rob, have you ever heard anything about the case against the guy who made a book out of Hunter's laptop? I'm curious where it stands. Well, that's Garrett Ziegler you're talking about. He's the author, along with the Marco Polo crew, MarcoPoloUSA.org, the Hunter Biden laptop. I don't know what the status of his case is. We should probably get together and do a Hunter recap. You know, it's been a while since Garrett and I had a conversation about that. But it's a great question, and I do hope it's going well. I don't know the details on it at the moment, but of course, Garrett Ziegler is being sued by Hunter and his, minions because he exposed him in that great book. And you can buy a copy of that book, again, at, I think it's MarcoPoloUSA.org, and follow Garrett Ziegler everywhere you can follow somebody because he's doing amazing work holding them accountable. But thank you, Michelle, for asking about it, and shout out to our friends at Marco Polo and to Garrett Ziegler. Okay, so my friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com, robertgovea.com for the newsletter and the PDFs. Don't forget to sign up at watcherlodge.com for our event on Saturday. And eat your greens. Go to fieldofgreens.com. Use code Robert when you check out to save that 15%. Before we go to Locals, shout out to our mods and our meme smiths, including Vienticus Prime, K-Bean, Just Cause, Playing Hooky. We got Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols, John Allen, Janek, Dog Digger, and Donut Mind Me, all modding down the fort for us, keeping things nice and orderly. We have Sleepy Dog Lee, Nathan N810, and G-Gum is back on Locals with the memes extraordinaire. And so that, my friends, is it for us on the day. Now, I wanted to read one final thing. I almost forgot. We had a very nice post come in yesterday that was from our friend Crash, and he wrote this, and he wanted to share it with us, and I promised that we'd take a look at it here today. So here was what Crash wrote. He said, I penned this for a different forum, and I updated it for today. Crash says, several beneficial definitions before you read John Adams' brief quote below. Rapine, the violent seizure of someone's property. Insolence, rude and disrespectful behavior. Avarice, extreme greed for wealth or material gain. Licentiousness, promiscuous and unprincipled in matters involving intercourse. But here's a quote from John Adams. John Adams said this in a letter to the Massachusetts militia, October 11, 1798. John Adams wrote, but should the people of America once become capable of that deep simulation towards one another and towards foreign nations, which assumes the language of justice and moderation, while it is practicing iniquity and extravagance and displays in the most captivating manner the charming pictures of candor, frankness, and sincerity, while it is rioting in the rapine and insolence, this country will be the most miserable habitation in the world. Because we have no government armed with the power capable of contending with human passions unbridled by morality and religion. Avarice, ambition, revenge, and licentiousness would break the strongest cords of our Constitution as a whale goes through a net. Our Constitution was made only for a moral and religious people. It is wholly inadequate for the government of any other. Says, let us not seek the Republican answer or the Democratic answer, but the right answer. Let us not seek to fix the blame for the past. Let us accept our own responsibility for the future. That came from JFK during remarks at Loyola College at an annual alumni banquet. He says just over a century and a half elapsed between John Adams' cynical foreboding and John Kennedy's Pollyanna-like remarks. But if we look at our condition today, with clear eyes, We will see that John Adams' admonition of future rapine, revenge, insolence, ambition, avarice, and licentiousness is our reality. A scant 62 years, almost to the day after JFK's remarks, we are mired in La Brea tar pits of our own making. Says ambition, revenge, rapine, insolence, avarice, and licentiousness, all six are on full display across this country, New York, Washington, D.C., Georgia, and Florida. God help us this year and the next. Absent a miracle, we are in serious trouble, very serious trouble. That's from Crash to the contrary on our locals. And thank you, Crash, for the nice dono and the message. We got Maynard, been a membo for 10 months, says mad liberals on X finding problems with the ballots in Georgia's RICO case. From Maynard. Maynard, thanks for being a membo for 10 months. Amazing. And this one's very nice from Ms. J. Thank you, Ms. J, for sending that one in and supporting our work here. Lady Ice says, I am thinking if they don't outright cancel the election with some kind of an event, they may just let him win and then claim voter fraud. I wouldn't put it past them to commit fraud in favor of Trump so they can make the case against him, putting an end to his claims in the last election, or maybe they are just not that clever. Says, I think the judge is really trying to do the right thing, especially after the subtle threats like an opponent materializing all of a sudden. Lord knows what he's doing. The only way to teach them a lesson is to call out their tactics. People are fed up waking every day to more and more corruption. Says Rob, for X, I believe you can subscribe to someone and Rob has to enable it. And Lady Ice says, I went out and canvassed for Lee Zeldin in 2022 for the 2 months. Very eye-opening. I totally recommend it to anyone who can because the opposition is out there in larger numbers. Exactly. They are getting organized. We have to do the same. Revolutionary Bliss says, getting close to the baby here. We sure are. About to pop. Member for 7 months, Revolutionary Bliss in the house. Thank you very much, Revolutionary Bliss, for being a membo for 7 months. Amazing. Okay, my friends, so that is it for us on the day. We are going over to watchingthewatchers.locals.com, and we hope to see you there. But if not, well, we're going to be back here tomorrow. It's going to be Thursday. We don't know if there's going to be a good drop from Judge McAfee, but there could be, probably on Friday. Regardless, there's going to be a lot to attend to and unpack, and we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. See you right back here tomorrow. Bye-bye.